After watching this video, you will be able to explain the concept of due process in the workplace, define employment at will and its ethical rationale, describe the cause of employment at work environment, discuss whether it's possible to downsize in an ethical manner, and describe the acceptable risk approach to health and safety in the workplace. Employment at will means employers are free to terminate an employee anytime for any reason. This means that employees are free to fire an employee at any time. Employers can dismiss their employee at will, be they many or few, for a good cause, for no cause, or even for cause that is morally wrong. The ethical rationale for employee at will has both utilitarian and deontological elements. Total discretion of manager over employment gives them the ability to make efficient decisions which should contribute to the greater overall good. Note, however, that this freedom is theoretically mutual, because in the same manner, an employee at will worker may opt to leave a job at any time for any reason, without offering any notice at all. However, employee at will also has its limitations: the justice argument, the property argument, and the lack of mutuality. Justice argument: even if employee at work proved to be an efficient management tool, justice demands that such tools cannot be used to harm other people. Property argument: even if property rights grants managers authority over employees, the right of private property itself is limited by other rights and duties. Lack of mutuality: though the freedom to terminate the relationship is theoretically mutual, the employer is often responsible for the employee's livelihood, while the opposite is not true. So the difference is that this creates an unbalanced power relationship between the two parties. The employer is in a more favorable position than the employee. So employers can tell employees what to do and when and how to do it. They can exercise total control because they retain the ability to discipline or terminate an employee who does not comply with their authority. Because of the immense value that work holds for many people, the threat of losing a job is a powerful motivation to comply. However, basic fairness demands that this power be used justly. Employers' decision to discipline employees must be implemented through due process. In France, for instance, French labor laws protect all employees from arbitrary dismissal. Employees cannot be fired as long as they maintain a good work record and as long as the firm is economically viable. In legal context, due process refers to the procedures that police and courts must follow in exercising their authority over citizens. Few dispute that the state, through its police and courts, has the authority to punish citizens. This authority creates a safe and orderly society, but that authority is not unlimited. It can be exercised only in certain ways and certain conditions, including recognizing human rights. These rights and these conditions is due process. The right of due process is the right to be protected against the arbitrary use of authority. Due process in the workplace also involves fairness in such things as promotion, salary, benefits, and employee separation. Such benefits can be used to motivate and also sanction or punish employees. Therefore, due process rights should also be extended to this aspect of the workplace in order to be fair. Downsizing is a difficult challenge to due process. Terminating workers is not necessarily an unethical decision. Downsizing decision raises ethical questions if there may be alternatives available to an organization in financial difficulty. The decision about who will be part of a downsizing effort must be carefully planned. The firm's decision must be based on some criteria that is fair and neutral to those concerned. When a firm decides to downsize, it is critical to lessen the impact as much as possible and to allow the individual to depart with dignity. Above all, it is critical to be honest and to have the sensitivity to the experiences of those who will be affected. Business organizations today must make decisions while respecting the rights of the worker. Basic worker rights is based on legislation, which include the employee's right to a minimum wage, to equal opportunity, to bargain collectively as part of a union, right to a workplace that is free from sexual harassment. Employee rights also refer to those goods that employees are entitled to on the basis of contractual agreements with employers, like the right to specific healthcare packages, paid holidays, and pension funds. Employee rights also refer to those entitlements to which employees have a claim independent of any particular legal or contractual factors. Such rights would originate with the respect owed to them as human beings or human rights. There is a wide consensus that employees have a fundamental right to a safe and healthy workplace. Still, in some regions, employees lack even the most basic health and safety protections, such as in working environments that are termed sweatshops. In this sense, it is important to recognize the responsibility of employers to provide a safe and humane working environment to employees, since it is through their labor that business profit is achieved. Risks can be defined as the probability of harm. Employers cannot be responsible for providing an ideally safe and healthy workplace. Instead, discussions in ethics about employee health and safety will tend to focus on the level of acceptable risk and relative risks. And we determine acceptable risk by comparing the relative risk or probabilities of harm involved in various activities like driving a car, cooking, taking a bath, or swimming, for example, and compare them with activities in the workplace. If it can be determined that the probability of harm in a specific work activity is equal to or less than the probability of harm of some more common activity, then we can conclude that this activity has acceptable level of risk. If the workplace was less risky than other common activities like riding a bicycle, exercising, eating, engaging in sports, management could conclude that they have fulfilled their responsibility to provide a healthy and safe workplace. What are the challenges with acceptable risk approach? The acceptable risk approach treats employees disrespectfully by ignoring their input as stakeholders. Such paternalistic decision-making treats employees like children, ignoring their role in the decision-making process. Unlike some daily risks freely undertaken by each of us, the risk faced at work can be controlled by others, and particularly by others who might stand to benefit by not reducing the risk. It assumes an equivalency between workplace risk and other types of risks when there are significant differences between them. Unlike daily risks, the risks faced in the workplace may not be freely chosen, nor are the risks faced in the workplace within the control of workers. Health and safety have a high instrumental value, since part of their value derives from the fact that we use them to attain other things of value. Whatever else we desire out of life, being healthy and safe makes it much more likely that we will be capable of attaining these needs.